Howdy, my name is Brian Foley. I'm a criminal defense lawyer here in Conroe, Texas, and I help folks who've been accused of a crime in Conroe, the Woodlands, Houston, and that general area. Today we're going to continue our lecture series on the rules of evidence. Today's rule is Rule 404. And in my blog series, I broke this up into two separate posts. Today we're just going to cover it in one video. It is the rule for character evidence. Character evidence, crimes, or other acts is the name of the rule. And so Part A talks about prohibited uses. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. So what does this mean? It means that you can't say, well, that guy's a good guy. He's normally a good guy every day in his regular life. He's got a good character. Therefore, he didn't commit this crime. Or the other way, that guy's a terrible guy. He's never done anything right. He's always been a criminal. He's committed crimes every day of the week for the last 3 years. So that means he committed the crime in this particular case. Neither side is allowed to do that, right? Oh, wait, except the first exception for this rule is that in a criminal case, a defendant can actually put in evidence of their character. And that's part two of the rules here. The first rule, A1, is the prohibited uses, which I just read. A2 is exceptions for the accused in a criminal case. And the rule says this: in a criminal case, a defendant may offer evidence of the defendant's pertinent trait, and if the evidence is admitted, the prosecutor may offer evidence to rebut it. Now, pertinent trait is the key word here. It doesn't mean that you get to just say that you're, let's say, for example, there's a case on point here for a sexual assault. The father in a sexual assault case was not allowed to put on evidence that he was a good parent, right? The court in Holt versus State, 912 Southwest 2nd, 294 from San Antonio, said that being a good parent was not the proper character trait for a defendant. The character trait in that one would be like sexual depravity, right? Something more focused on the crime. Being a warm and caring person wasn't relevant to the elements of murder, right? It would be a character for peacefulness is what they say, or a character for violence. Is this person a violent person or generally a peaceful person? You could put on evidence of that, but you can't just say a warm and caring person. That is according to Mowbray, Mowbray versus State, 788 Southwest 2nd, 658. So what is the rule here? Again, it's kind of like you can't say that once a criminal, always a criminal. That's for sure. The prosecutor can never do that. But you do get a few exceptions as the criminal defendant. You get to come up with what is the character trait, right? You get to say, let's say it's a theft case. It's your character for honesty, for not stealing, for being respectful of people's property. You can say stuff like, oh, well, I was with the defendant one day and he got too much change back at the gas station. They gave him an extra 20 and I saw him give it back to the gas station. This is the kind of character that this defendant has. It's a character for honesty with dealings in, like shoplifting or something like that. If they were accused of shoplifting, that would be a great piece of character evidence you could put on. Okay, so the next part, there's an exception for a victim. In a criminal case, subject to the limitations of Rule 412, which is called the Rape Shield Law, you can't say that somebody was sexually promiscuous or consented to sex on some other occasion and therefore did on a particular occasion. So subject to those limitations, a defendant may offer evidence of a victim's pertinent character trait, and if the evidence is admitted, the prosecutor may offer evidence to rebut the same. So if somebody has a character trait for being a hothead, getting in fights all the time, he was at let's say you offer character evidence in the form of opinion or reputation, and you bring in somebody who knows the victim in a murder case, and they say, this victim, I've been the owner of this bar, and I know this victim's character, he's a hothead and he's always looking for a fight. I would not be surprised if he was the aggressor in this case and that, the defendant had to defend himself, and that's what resulted in this killing. So that is another allowable one. There's an exception specifically for homicide cases. In a homicide case, the prosecutor may offer evidence of the victim's trait for peacefulness to rebut evidence that the victim was the first aggressor. So the reverse there is true. So if you're going in a homicide case to talk about, something like the victim's character for violence, then the prosecutor gets to talk about and bring in witnesses to rebut and say, yeah, no, he was a very peaceful person. All right, let's talk about subsection B, which is permitted uses for crimes, wrongs, or other acts. Subsection B first says you cannot use evidence of a crime, wrong, or other act to prove a person's character in order to show that on a particular occasion the person acted in accordance with that character. That's what the rule says. But subsection 2 says you can admit that evidence for another purpose, like motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake. This is not an exclusive list either. And so that means any reason other than character for conformity that a prosecutor can come up with, the judge may entertain entering that evidence. And so this rule, 404B, is really like the loophole rule. All the bad character evidence that ought to be excluded may come in when we're looking at Rule 404B. So let's go over some examples. So motive is one. What is the motive of this person? So like if there's a murder, okay, and there was also a sexual assault, okay, and the person went to prison for sexual assault of this person, and they said while they were in prison, when I get out, I'm going to kill you because you helped convict me of this sexual assault. Well, now maybe it would be relevant to discuss the sexual assault and the fact that he went to prison for it, because that is the motive for the new crime. Okay. Another classic example of motive is that prosecutors will try to use is if you have drug convictions and you're being alleged to have committed a burglary, well, they could say that the motive for commission of the burglary is to feed the defendant's drug habit. And I think that one would get a lot less traction nowadays. But when these rules were first being implemented in the 80s and 90s, that rule and that example was a lot more prevalent. I'm not even sure that a prosecutor would try to do that nowadays. And I think that if you objected under Rule 404 and Rule 403, you'd probably get a lot better results than in past years. So that's the basics of Rule 404. You can't get into bad character evidence, but if the prosecution can find a reason, some other reason like motive, opportunity, intent, common scheme, plan, preparation, something like that, then they're going to be allowed to get into it by the judge. It is ultimately up to the judge's discretion. But one thing for defense attorneys to note in this regard is that your actions as the defense attorney can influence whether or not these prior convictions come in. Right? Maybe there's no good reason for the prosecution to get into it at the beginning of the case. But in your opening statement, if you say that, the defendant has always been a peaceful person, there's never been any disputes, and you're going to see that, that he didn't even know this guy on the day of the murder, well, then if there's some prior assault between the two people, then that's coming in. In a murder case, that might be a little bit of a bad example because there's a lot of other statutory rules that allow for evidence in a murder case to come in. The same is true for family violence cases. There's a new section of the Code of Criminal Procedure that allows a judge to enter in prior evidence of crimes, wrongs, things like that between the defendant and the victim or the alleged victim, in order to explain the nature of the relationship. And that can go both ways. So the defense should be able to get into things if the victim maybe has been violent in the past towards the defendant, and then the prosecution can get into them if they have proof the defendant has been violent towards the victim. Thanks for watching. Click that like button and subscribe if you enjoyed it. Share with your friends. And as always, this information is just for educational purposes. If you need a consultation, give me a call. If you're another lawyer out there and you need advice on the law, you can call me for that too. I'd love to help. Thanks so much.